5 estate planning mistakes to avoid for a smooth journey. Well, that's what we're going to cover in today's video. Hi, my name is Chuck Roulet. I'm an attorney licensed to practice law in both Florida and in Minnesota. And before we get into the video, if you haven't already, make sure you hit the like, subscribe, and bell notification so you'll be notified when we upload additional videos. And go ahead and feel free to share this out on social media. So 5 of the most common estate planning mistakes I see as an attorney and how to avoid those for a smooth journey for your family. Well, that's what we're going to cover in today's video. So the first mistake I want to talk about is procrastination or delaying the planning process. Now, I get it. It's tempting to push estate planning to the back burner. After all, it's not urgent and it's not an enjoyable task for most. However, postponing can leave you and your family, vulnerable. And in fact, I recently shot a video discussing this where a woman contacted me. Her partner had passed away very unexpectedly without any type of plan in place. And she and her partner's brother were really struggling. They didn't have access to any, checking, savings accounts to pay funeral expenses and other bills. We're wondering how to go about paying the mortgage and the credit cards and the car payments, and had just really left a big mess. And so while it's easy to put planning off, the fact remains if you don't have a plan in place, the government has one for you and your family. And it's usually, in my experience, the most stressful, the most expensive, the most complex, and most likely to cause family disputes. So delaying the planning process, procrastination, one of the biggest mistakes we see. The next mistake we want to talk about is failing to update outdated documents. Now, major life events like a marriage, divorce, new child, that should all trigger a document review. And even if you haven't had any of those, we usually suggest to our private clients that they should, look at their docs about every 3 to 5 years. Now, that doesn't mean a change will need to be done or that they will need to be updated, but it's a good idea to check in every few years. Even if there hasn't been a change in the law or any of those events, often just want to make sure that the people you've named as your personal rep, your exec, your successor trustee, healthcare decision maker are still who you want. Now, here's sort of a worst case scenario example. A number of years ago, I was contacted by, I'll call them, kids, but it was a brother and sister, kind of mid to late 20s. And their dad had recently passed away very unexpectedly. And he had an old will in place that he had put together while the kids were still minors, while they were still young. And in it, he had named his sister, the children's aunt, as the executor of his estate. Well, here was the issue. In the time from when he had done that will to his passing, he'd had a significant falling out with his sister. They were not on speaking terms. She was not on good terms with the kids. And now she was the one that was going to be, in charge of everything. And, they were wondering, could we have her removed, whatnot? And I kind of explained that, courts were pretty loath to overturn something like that. So again, classic example, dad had done a will while the kids are young, had not gotten around to updating it. And now somebody that he was not on speaking terms with was going to be put in charge of his estate when his kids were now at a point where they really could have stepped in and done that. So again, that's just one example of the dangers of having outdated documents. Now, the third mistake we want to talk about is overlooking incapacity planning. So if you were to become incapacitated, couldn't manage your financial affairs, couldn't express your wishes for your health care, absent something else, no one's got the legal authority to step in and do that for you. So somebody's going to have to petition a court in what's known as a guardianship or a conservatorship proceeding. Now, depending on court calendar, that can take a couple of months, a few $1,000s just to even get in front of the judge. Then the judge is going to decide who's in charge. But the big takeaway is that once the court's involved in your life, they tend to stay involved in your life. So there's ongoing costs to continue that. So that's why we tell all of our clients, usually the first place to start with any planning is making sure you have good, up-to-date financial powers of attorney and healthcare documents. So if you become incapacitated, a spouse, a friend, family member, somebody you trust has the legal authority to step in and manage finances and make medical decisions. Now, the next common mistake that I see that we want to talk about it is trying a do-it-yourself estate plan. Now, I understand the appeal of do-it-yourself estate planning, but it tends to cause more problems than it solves. So again, another classic example of this is there was an infamous case in Florida just a few years ago. A woman had done a will on her own. We're not sure where she got the template for it online or whatnot, but did a do-it-yourself will. And unfortunately, the will was missing a very sort of common provision that us as attorneys would have made sure was in there. But as a result, when a sibling passed and she inherited some land, the will didn't address that. And when she eventually passed away, then the family went to court to fight about who should actually end up, owning or inheriting that piece of land. And the case went all the way to the Florida Supreme Court. And in the court opinion, I think it was the Chief Justice of the Florida Court of, the Florida Supreme Court said this was a perfect example of being penny wise and dollar foolish, and pointed out that, it was pretty evident from the woman's will that she most likely would have wanted this piece of property to go to one set of family members. However, because the will was done incorrectly, and because of the law, the court was required to give the property to a different set of family members. So again, the judge was clear. The will, we kind of know where, we can make our best guess about where she would have wanted it to go, but the law requires us to do something else because this will was done incorrectly. So not only did the piece of property go to somebody she probably didn't intend, but the family ended up spending many, many multiples of what she would have spent getting good guidance and a correct plan on litigating this thing from the district court to the Court of Appeals all the way up to the Supreme Court. So again, it's a classic example of sort of the dangers of do-it-yourself estate planning. Now, the fifth item we want to talk about, one of the fifth most common mistakes, is not protecting assets from long-term care and nursing home costs. One of the biggest misunderstandings I see in the general public is they think, well, if I have a will or a trust, that actually protects my home and life savings from long-term care and nursing home costs. And the fact is, it doesn't. So while we want to make sure everybody has what we call foundational estate planning in place, which is your powers of attorney, healthcare directive, a will and or trust for management of your assets after you pass away, those docs by themselves do not protect assets from long-term care and nursing home costs. In fact, you need to do another round of planning, okay? So 5 of the most common mistakes we see in estate planning and how you can avoid them to make it as easy and inexpensive and much smoother for your family. So if you are in Minnesota or Florida and you would like to get a plan in place or to update an existing plan or to do some additional planning to help protect your home and life savings from long-term care and nursing home costs, please contact us. We'd be happy to help. We have a link to our website in the description below. If you're not yet ready to move forward and you'd like some additional information, I'm actually going to be hosting a free online masterclass. And again, there's a link in the description below. Just enter your name, email, completely free. And in that class, we're going to be talking about some of the insider strategies for making it as easy and expensive for your family during incapacity or after your passing. We'll talk about powers of attorney, healthcare directives, wills versus trusts, how to choose the right one for you. We'll talk about how to minimize estate taxes. We'll talk about how to shield the assets you leave for a spouse, how to protect assets you leave for your kids, make sure that they don't lose it if they get divorced or sued or something happens. And I'll actually be sharing in there some of the strategies I use with my private clients. Again, completely free, link in the description below. And if you'd like to learn more about how you can protect your home and life savings from long-term care and nursing home costs, I've actually written a free consumer guide, Save Our Home, How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. And there's a link in the description below for that. So again, just input your name and email address. You can download it free from the link below. So I hope you found this video helpful and look forward to seeing you in an upcoming video. Be well.